Dear comrades, yours Kayveeyes. Let us discuss about the present position and the issue of grant of notional increment to the June 30th retirees. The writ petition was filed by Sri I.M. Perumal in Madras High Court 15/7/32 of 2017. The Madras High Court held that since he had completed 1 year on the date of retirement, increment should be given and taken for the pensionary benefits. Instead of implementing the judgment, the government has moved the SLP in the Supreme Court under number 22283 of 2018, which was dismissed on 23/7/2018. Again, review petition was filed under number 1731 of 2019, which was also dismissed on merits on 8/8/2019. So the government has no other alternative or option, and hence the government has implemented the court direction exclusively to the applicant Sri I.M. Perumal and circulated to all that the judgment is in persona and not in rem. That is, it is applicable to the person who approached the court and it is not applicable to the similarly situated persons. Thereafter, more petitions were filed. Mumbai High Court in the writ petition of 6396 of 2020 held on 24/6/2021 that the benefit should be extended based on the I.M. Perumal judgment. In the writ petition number 10509 of 2019, in the case of Gopal Singh, Delhi High Court delivered on 23/1/2020 to extend the benefits of the I.M. Perumal case judgment. Thereafter also, the government moved another SLP under number 13959 of 2020, which was also dismissed on 13/10/2020, stating there is no reason to interfere. Again, review petition was filed in the Supreme Court under number 6844 of 2021, which was also dismissed on 26/7/2022, stating that did not find any reason for reconsideration. We have discussed elaborately about this judgment in our previous episode. Further, against the Lucknow bench judgment in the civil appeal in the Supreme Court 7970 of 2022, which was also dismissed on the same plea, as we do not see any cogent reason to interfere. Actually, the government is depending only one judgment, that is the interim judgment granted in the case of M. Siddharaj versus Railway of the Karnataka High Court judgment. The Supreme Court in the SLP 4722/2021 passed an interim order on 5/4/2021 for the stay of operation of the Karnataka High Court decision in the case of Sri M. Siddharaj versus Railway. Because of this, even though all the cases were dismissed, all the SSPs were dismissed, all the curative petitions were dismissed, the government is still depending upon the case of M. Siddharaj versus Railways, wherein an interim order was passed by the Honorable Supreme Court of India. In the discussion held in September 2022 with the JCM Standing Committee, it was replied that the issue will be decided based on the decision of the SLP in the case of Siddharaj versus Railway about Karnataka High Court judgment. Actually, the case related to Siddharaj was pending in the Supreme Court, which is not yet decided, whereas the SLP filed in the case of Siddharaj under number 4722 of 2021 came up for hearing on 5/4/2023 in the Supreme Court. The Supreme Court ordered that the question involved in these special leave petitions have already been heard by the different branch, and so the judgment is reserved. So accordingly, the judgment is reserved. The next date is tentatively listed on 28/4/2023. So we are expecting a final outcome on 28/4/2023 in the case of Siddharaj. If the Siddharaj case is decided in favor of the official, there will be no other chance to government except to implement the decision of the I.M. Perumal case. So, we are awaiting for 28/4/2023. In the meanwhile, there is another development in the Supreme Court under SLP 6185 of 2000 in the case of KPTCL and others versus Mundi Namani and others in the disposal of the Karnataka Writ Appeal 4197/2017, the SLP was also dismissed in the Supreme Court. So almost all the cases in the Supreme Court, they were decided in favor of the officials, and the government moved on each and every SLP. All the SLPs have not been admitted in the Supreme Court. So this is the current position, and we are expecting on 28/4/2023, we are expecting a favorable judgment. It cannot be protracted furthermore in this case. Let us hope, let us confidentially await for the judgment. With this, I am concluding this episode. Thank you very much, comrades. Meet again.